Victoria, do you want to go ahead and start your presentation? That way I can go ahead and send it to the live feed, and that will be the first slide up.
Sure, I can do that.
I just want to make sure that it's going to go through. Sometimes it makes me restart it.
Are you able to see the presentation now?
I am.
Excellent.
All right.
Actually, what we're seeing, Victoria, is are you using
the
screens?
deck.
I'm sorry?
It looks as if we're seeing two screens.
Oh.
The current
Oh,
slide.
it's the presentation. I mean the presenters mode. Yeah.
Yeah.
How do I get that off presenter mode? I wonder if now is it still two screens?
There is one.
Now it's just the one.
Okay.
All right, give me 1 second. I am sending it and we'll be ready to start. I'll give you a countdown.
Okay, I'm going to turn my video back on.
Okay, I'm going to go ahead and pin you, and I'm going to mute myself.
Okay.
All right, give it about 20 seconds as it loads.
Okay.
I thought it was ready to go.
No problem. You know what? I will wait until my computer says 6:01, and then I'll do my introduction. How about that?
Yeah, we are actually good right now. I'm seeing the presentation live, and you are up in the corner. So as soon as you're ready to go.
Great. Good evening. My name is Rod Smith, Director of Place-Based Initiatives at United Way of Forsyth County. And I would like to thank all of you for joining us for this evening's discussion related to understanding heired property. This workshop comes out of United Way's Place Matters partnership with the Wake Forest University's Community Law Clinic and the Law Clinic's intentional engagement to be involved in the community that we all call home. Tonight's session on heirs or heired property is especially the result of conversations with the residents of the 13 neighborhoods that make up the Place Matters initiative, and is an ideal representation of the basic tenets of place-based initiatives, that it is asset-based, resident-led and informed, and engages the community's leaders and stakeholders. I would like to now turn it over to Steve Virgil. Steve is the director of the Wake Forest University Community Law Clinic, and he will introduce this evening's presenters. Right now, most of us, if not all of us, if I'm not mistaken, are on mute. If you have any questions, we'll take questions at the end of this evening's presentation. You can hold them until then, and you can also put them in the chat. And so again, thank you for being with us this evening, and I'll turn it over to Steve.
Yes, well, I'd like to echo Rod's greeting and say thanks for being here. I work at the Wake Forest School of Law, where I'm fortunate to teach some of the finest students that we have in our university as they begin their career. I'd like to introduce Victoria Dishner and Laura Jordan, who will be leading the conversation today. They've done a tremendous amount of work on the question of heirs property. And we all know that heirs property is a significant challenge to many families as they try to maintain their housing. And so we hope to pass along some information about how a family might navigate an heirs property situation. And if you have questions after this presentation, please feel free to reach out to us at 336-758-4950. And with that, I will turn it over to Victoria and Laura.
Thank you, Professor Virgil. Good evening, everyone, and thank you for joining us tonight. My name is Victoria Dishner, and this is Laura Jordan, and we're students in the Wake Forest School of Law, Community Law and Business Clinic. And we're excited to share with you what we've learned, the information on clearing title to heirs property, which could benefit many members of our community that may be living in their deceased relatives' homes and might be without the ability to take out a mortgage or receive repair grants for that home. And I want to quickly note that, see if I can get back to my presentation here. I want to quickly note that the information we're providing in this presentation does not and is not intended to constitute legal advice. But if you are interested in obtaining legal advice based on the content of our presentation, you should contact an attorney to discuss your specific situation. And you can also reach out to our clinic, which Laura will tell you a little bit about.
Thanks, Victoria. So here's the information on how to contact the clinic. Our clinic specializes in providing free legal services to those in the community on matters such as small business and startups, nonprofits, art and intellectual property, consumer transactions, foreclosures, heirs property, and more. So Wake Law students serve as certified student clinicians under the supervision of attorney, director, and clinical professor Steve Virgil. On the final slide of this presentation, we'll show this contact information again. So for our presentation, we're going to start off with our key definitions to explain what heirs property means and how it occurs. So who is an heir? Colloquially, heir has come to mean anyone who receives anything under a will or without a will when someone dies. However, legally, an heir refers to someone who inherits real or personal property from someone who dies without a will. Those who inherit are family members related by blood, such as biological children or a biological parent, or family members related by law, such as spouses by legal marriage or children by legal adoption. So who isn't an heir? This would be people outside of your legal family, such as close family friends. They can receive property if you leave it to them under a will, but not if you die without a will. This also includes children who you have raised but have not legally adopted, and legally divorced spouses. In essence, this is all non-family members are non-heirs. Next slide. Okay. So what does it mean to die intestate? According to Black's Law Dictionary, intestate means the quality, state, or condition of a person's having died without a will. So when a person dies intestate, he or she dies without a will. And combining this with our definition of heir, an heir is someone who receives property after someone dies intestate. So where does the property go when you die without a will or you die intestate? When you die without a will, North Carolina General Statutes Section 29 governs which particular heirs the property goes to. These are called intestacy laws or intestate succession laws. They refer to the person who died as the decedent. And circling back to heirs property, this refers to property that is passed through intestacy laws instead of through wills to multiple heirs, or often through a series of generations. The Heirs Property Retention Coalition explained it really well. So quoting them, without a will or carefully drafted will, property quickly descends into an untenable multi-owner situation. For instance, if an owner passes away intestate, i.e. without a will, and that owner has 5 children, those 5 children will each have an undivided 1/5 interest as tenants in common, which is the legal term for heirs property. Undivided means that each has the right to use and occupy the entire property. If each of those 5 heirs then has 5 children themselves, then when the original 5 heirs die, there will be 25 owners. As the generations pass, there are more and more owners, sometimes hundreds, end quote. So therefore, this property of land, or this process of land passing through multiple hands, often ends in each person having an extremely fractionalized ownership interest, and the current deeds to the homes don't reflect this. The main issue with heirs property is that the deed to the property is not updated as it passes to each generation, which causes technical, legal, and tax difficulties down the road. So now let's shift to what to do when property is descended to multiple heirs through the generations, resulting in heirs property. The process of clearing title means replacing the name of the deceased owner from the property deed with the heir or heirs who have inherited the property. This process can be aided by our Wake Forest Law, Community Law, and Business Clinic, or resources such as the South Carolina Center for Heirs Property in Charleston, South Carolina. So why should you update the deed with the current heirs' names? So the Heirs Property Retention Coalition again explained this really well. They said, unfortunately, fractional ownership greatly increases the risk that an heir or a land speculator who has purchased an heir's share will attempt to force a partition sale, or that the land will be lost to tax default. Worsening the problem is that many default rules governing such legal processes, particularly governing notice and the examination of the party's interests, are fundamentally inequitable. For instance, the partition laws in all states permit any one of the fractional owners, no matter how small their share and how recently they acquired it, to ask a court to sell the entire property at an auction against the will of all of the remaining owners. In some states, if the court finds that dividing the property would prejudice even one owner, the court can order the entire property sold. So partition sale is a real risk and is why finding all of the heirs and then consolidating ownership of the property through sale of fractional interests to one heir or a trust is really important. Also possible once you clear title is the ability to obtain a mortgage, to build another home, to obtain grant funds for home repairs, or to start a small business. So how to locate heirs? So locating all of the heirs is vital, but how is it possible if the property is passed through several generations? So first, you must figure out which groups of people would have been left the property through intestacy laws. We've listed here the pertinent North Carolina statutes to guide this process. These statutes are all available online, and a link is provided in the sources page to this PowerPoint. They direct how the property is split if there's a surviving spouse, children, parents, adopted children, etc. So once you've figured out which groups of people would have been left the property through North Carolina intestacy laws, there are resources available to help fill in the blanks of who specifically has an ownership interest in the heir's property. The National Genealogical Society provides several helpful areas to begin your search, such as looking through family vital records, family Bibles, contacting knowledgeable family members, filling out a family tree, searching on Ancestry.com with a free trial, looking through census records, looking through city directories, and finally finding records at the county courthouse on wills, probate, land, and deeds. So luckily we live in the age of technology, and several resources such as text, information, deeds, and more are available in your North Carolina County website. So Forsyth here. So Forsyth County has digitalized deeds going back several decades, and they're all available on the online register of deeds. This portal allows you to search for deeds by sellers and buyers' names, which are listed as grantor and grantee. They have scanned pictures of the deeds that are available, and if the deed is too old, then you can call your Register of Deeds office or the county tax office, and someone will be able to help you find it and will send it through email, or you can come pick it up. And then also available online is the Forsyth County GIS data viewer. With this online portal, you can search with an address and then find a number of different things about it. The parcel number, the last recorded owner, owner history, legal description, deed book and page, plat map book and page, total building value, property report, tax bill, tax appraisal information, basically everything you could want. And let me turn it over to Victoria.
Thanks, Laura. So now we're going to talk a little bit about the steps that a person must take in order to actually clear title to the heir's property. And most of these steps just involve utilizing all of the tools that Laura has just shared. So the first step to clearing title is to locate the current deed. And this is a very simple step if the person that's living in the house has a copy of the deed with them or available to them. And if not, the easiest place to locate the deed would be on the Register of Deeds website for the county in which the property sits. And as Laura mentioned, you can search for that deed by the buyer or the seller's last names. And then next, you'll locate all living heirs using any of the methods that Laura shared. And additionally, the Georgia Heirs Property Law Center has a step-by-step heirs determination worksheet that I've found really helpful. And although it's designed for Georgia, it can be helpful in any state. If you just Google heirs property worksheet, there are several resources. And then after locating all of the living heirs, the next step is to locate any existing wills. And again, locating wills is really simple if the person residing in the home knows where a will is for the person who is listed on the deed. But wills are often kept in safe places, such as safes, safety deposit boxes, or locked desk drawers. And also, wills are sometimes held by the decedent's attorney. And prior to death, a decedent also may have deposited a will for safekeeping with a clerk of court. So you can check all of those places when looking for a will, and also consider contacting the clerk of court in counties where the decedent formerly lived if no will is found in the current county. And then after locating any existing wills, the next step is to determine whether the probate estate must be reopened. So if a will exists and the decedent's other property besides the heir's property has already been divided up in a probate court, the estate will need to be reopened. And I will talk about the steps of actually reopening the probate estate in a few slides from now. But first, if there is a will and the estate has not been probated yet, the next step would be to visit the clerk of court to apply for letters testamentary. And some counties permit walk-ins while others require appointments. So the easiest thing to do is just call ahead and see what their process is. And letters testamentary are legal documents that are issued by the clerk of court that give a person the authority to serve as a personal representative for the estate. And these letters are often requested by institutions like banks or insurance companies during the estate administration. Some individuals by law are not qualified to serve as a personal representative of a decedent's estate. And also the law gives some people priority rights to serve as a personal representative over other people. If there is a valid will, an executor named in the will has the highest priority to receive the letters. And if the executor does not qualify, then there could be a substitute or a successor named in the will that will have the next priority. And if the will does not name a substitute or successor, then those who may be granted letters are in the following order of priority. First, the surviving spouse, then anyone receiving property under the will, then anyone who would receive property if there was no will, and then fourth, any next of kin, fifth, creditors of the decedent, and sixth, anyone of good character living in the county. And it's important to note that some people are disqualified from serving as a personal representative. So in the state of North Carolina, no person may serve as a personal representative if they're under 18 years old, or if they've been adjudged incompetent by a court and remain under that disability, if they're a convicted felon whose citizenship has not been restored, if they're a non-resident of the state who is not appointed a resident of the state to accept service of process. There are a couple of other things listed in the statutes as well, but another important one is someone who can't read or write is not able to serve as a personal representative. If there is no valid will, but the decedent's property has already been divided up in probate court, then the estate will need to be reopened, and I'll discuss that in the next slide. But if there's no valid will and the decedent's property has not yet been divided up in probate court, the next step is then to visit the clerk of court to apply for letters of administration. And letters of administration are just like letters testamentary, except the letters of administration are reserved for instances where the decedent did not have a will. So the letters of administration still give a person the authority to serve as a personal representative of the estate. The order of priority of those who can be granted letters of administration are in the following order of priority. First, a surviving spouse. Second, anyone receiving property under the will. Third, anyone who would receive property if there was no will. Fourth, any next of kin. Fifth, creditors of the decedent. And then last, anyone of good character living in the county. And now we will discuss a little bit about how to reopen a probate estate in North Carolina. Under North Carolina law, an estate may be reopened under certain circumstances, including the existence of newly discovered property. And so if the heir's property was not probated previously, it could be considered newly discovered property. As an initial matter, it's very important throughout this process to keep accurate records and file accurate accounts of property dispersed and any expenses incurred by the personal representative. And also, the clerk's office may inform the personal representative from time to time of court costs and fees, and all of these costs and fees must be paid as part of clearing the title. Each county has varying fees, and the best way to find out the exact amount is to either call the clerk of court or to visit the Superior Court's website, and they will have listed an estate's fee schedule. So once you've determined that the estate needs to be reopened, you can file a petition to reopen the estate with the probate court, and that's the Superior Court in the county in which the property sits. The person filing must be an interested party, meaning that he or she must have a financial interest, such as being an heir of the property or a creditor of the estate. And the filing fee to reopen the estate can range from anywhere from $15 if it's a really small estate to $6,000 if it's a really, really large estate. And this all just depends on the value of the heir's property. North Carolina makes this petition process very simple. It has this fill in the blank form pictured here on the left side of the screen. That form is listed on the probate court's website, and you can also get there more easily just by Googling petition to reopen estate, North Carolina. The petition requires that you list the contact information of the personal representative, and then also list the assets left out of the last estate administration, which in this case would include the heir's property. Then the clerk of court would sign and return the petition, noting whether the estate has been reopened or whether the petition is denied. And again, North Carolina law provides that the discovery of new property is a circumstance in which reopening an estate is appropriate. So the denial of a petition would be very odd if there actually is extra property. The person completing the petition would then step into the shoes of the previous personal representative of the estate. Once a person has become a personal representative of the estate, whether by reopening the estate or applying for letters testamentary or letters of administration, the next step would be to notify any interested parties. And the personal representative must place a notice for creditors' claims against the estate in a newspaper that's qualified to publish legal advertisements, and that must be published in the county where the estate is being administered. And if there's no qualified newspaper that's able to do that, then the notice must be published in some newspaper of general circulation and then also posted at the courthouse. Or also you could do a copy of the notice that's posted at the courthouse and in 4 other public places in the county. And the notices to creditors must be published once a week for 4 consecutive weeks. And the notice should state that claims must be filed by a date that's at least 3 months out from the first time that notice was published. And additionally, the clerk may direct that notice be given to the heirs on the original probate petition if those heirs are known. And all in all, the clerk has a bit of discretion here in directing the notice procedures, so it could vary from case to case. And once the notification process is complete, the personal representative may need to pay the cost of administration or taxes or any other valid claims against the estate, if any exist. But then the next step is to settle the property, which will primarily involve acquiring quitclaim deeds from every interested party other than the person that's seeking to clear title. A quitclaim deed is just a legal document that transfers whatever property ownership the grantor had in the property to the grantee. And as Laura mentioned earlier, a grantor is someone who had an interest in the property. So in this case, the other heirs who are not living on the heir's property. And the grantee is just the person who seeks to receive that interest. So usually the person residing on the heir's property. A quitclaim deed makes no warranties or promises about the grantor's rights in the property. So the grantee can't come back and sue the grantor if the grantor never had any rights in the property, because this type of deed merely serves to give up whatever interest the grantor did have, if any. And a quitclaim deed also prevents the grantor from returning to assert any ownership interest in the land, which is important particularly for heirs property. There are a couple of vehicles through which a person can give up their rights to property in a way that benefits the current resident of the heir's property. And the first method is issuing a quitclaim deed to an individual, specifically the person living in the home that's trying to clear the title. Another option is that an heir with an interest in the property could grant a quitclaim deed to a trust created for the purpose of protecting the heir's interest in the property. And this can simplify decision-making, but it requires the formation of a whole new legal entity. So if you're interested in setting up a trust or seeing if a trust would benefit your specific situation, you could contact our clinic or an estate's attorney to walk you through that process. And whether the quitclaim deed is issued to an individual or to a trust, a deed must be filled out from every person who has an interest in the heir's property to the person seeking to clear title. And here on this slide, we've included a sample quitclaim deed, and this one's actually from Davidson County, North Carolina, but they're all very similar. They're simple documents, and there are many free forms available online. And the basic portions of the deed are listing the name and the contact information of the grantor and the grantee, as well as the map information to locate the heir's property, which Laura showed us how to find that either on the original deed or on the GIS data viewer. And here is just the second page of the deed. And this deed provides spaces in the top right-hand corner for several different grantors to give up their interests in the heir's property, all on the same document. So if all of the grantors are local and close by, this might be one option instead of sending out several different quitclaim deeds, but either option is fine, just whatever is most convenient for your situation. And then the quitclaim deed must be notarized and then filed with the county register of deeds wherever the property sits. So there is a filing fee for quitclaim deeds. And in Forsyth County, the fee for filing a standard real estate instrument is $26 for the first 15 pages and $4 for each additional page. But as you can see, this sample quitclaim deed is only 2 pages, so the fee would be $26. As I mentioned before, the personal representative who opened or reopened the estate must take care of any estate taxes or valid claims against the estate, if any are outstanding, before the court will discharge the personal representative. But once all of the property has been distributed and all the fees paid, the personal representative may close the estate by filing a closing affidavit with the clerk of court showing that all of the property has been distributed. And then that concludes the heir's property process. And that also concludes what we have for our presentation. So thank you for sharing your evening with us. Let's see if I can get to our contact information. Yes, we're the Wake Forest Community Law and Business Clinic. And if you have any questions, I'm sure Professor Virgil will help us with those. And if you have any questions for our clinic, feel free to reach out on our website or on our telephone, email. All of our contact information is there.
Well, thanks for that. That was super interesting. I found it super interesting. I think that one of the questions I have immediately for you all, if I may, it's kind of technical, right? There's a number of things you talked about, that like processes that were really sort of technical, and then also having the right document to file, knowing where to file it, knowing what fee to pay. How do you suggest folks sort of navigate all of those steps? What's the easiest way someone could find to navigate all those technical steps?
Steve, actually, if I could maybe add to that just before Laura and Victoria give us their answers, because I had a very similar question. One of the reasons that we're here tonight is that in our conversations with the residents of those 13 neighborhoods, this issue in particular came up several times. And what they were telling us is that many times, let's say, an adult grandchild moves in with a grandparent who has become ill, and during that time that's where the grandchild lives. That's the only home they have, and the grandparent passes away without a will. And so maybe just in terms of some context, that might be where Laura and Victoria could take us. How do they advise that that adult grandchild whose home is essentially where they live with that grandparent, and now that grandparent has passed, what are their next steps?
Well, I think that the easiest or the most surefire way to get a correct answer would be to speak to an attorney. But there's also, if it's a smaller estate, there are handbooks on the North Carolina Probate Court website that will walk you through the steps. It lists them out like 1 through 20 of how to become a personal representative, which documents to file. And those are all available for free on the North Carolina Judicial Branch website.
And the grandchild in that instance would be an interested party that would have the ability to file and proceed with opening an estate and getting administrative powers to have a deed issued. Is that correct?
Yes.
Yes.
Well, are there other questions from the group?
There's actually one in the chat, and let's see if I can get to it. And this one comes from Michelle Taylor. Michelle asks, is North Carolina considering enacting the Uniform Partition of Heirs Property Act, also known as UPHPA? It has been enacted in 17 states, including South Carolina and Georgia, our neighbors to the south.
I actually had the same question as we were researching, because I saw that it's very helpful in all of those 17 states. It allows not just one heir to be able to force a partition sale. So if there's 5 grandchildren and one of them doesn't want to keep the land as a whole and wants their 1/5 money out of the land, if they go to the court has to sell it if one of the heirs wants them to. And so the UPHPA basically allows them to keep it as a whole and not just allow one person to have that power. But I didn't see anything online about North Carolina going toward adopting it, unfortunately.
I will underscore that. I'm not aware of any effort to have it passed in North Carolina, at least in the past 5 years, 3 to 5 years, maybe before that. So it is certainly an area that would have huge benefits, right? It would enable, as Laura notes, enable someone who needs the housing, needs the property to stay in the house and avoid a partition sale, and also allow for value to be kept in the family. Is that right, Laura?
Yeah, exactly.
And a question that I have after And well, before I do that, let's answer this question from Braden Johnson. Let's open the chat so we can see Braden's question. There, Braden says, piggybacking on my example, what if there is a grandchild in the home, but an uncle or aunt wants money to give up the property? Where would you start to begin the process? And I can repeat that. It says, what if there is a grandchild in the home, but an uncle or aunt wants money to give up the property? Where would you start to begin the process? And so that sounds a lot like the question that Michelle had posed in terms of the Uniform Petition Act. So can you all address that?
One thought that I had was that they could possibly sell, they could both get their names on the deed through the probate process. And then the aunt or uncle could sell their interest to the grandchild who wants to remain in the home. And then that sort of consolidates interest so that the grandchild then can continue living there, but the aunt or uncle can have the money instead of the aunt or uncle just going to the court and forcing sale of the whole land. They could just get whatever they are asking for it from the grandchild, possibly.
Thank you. And this is another question I have. You all will excuse my ignorance of the law, but is there anything such as squatters' rights? Like, does a person in the home have more rights than a person who is not in the home? So let's, we're going to pull the grandchild out of the example. This aunt or uncle that was in Braden's example. So there are two children, one who is in the home and one who isn't. Does one have any greater rights than the one who does not currently live there in the home?
Unfortunately, no. As it is right now, if someone has an interest in the property, it doesn't come into play whether or not they live on site at the property. They can still force a partition sale just as easily as any other heir.
Okay. So playground rules do not apply whenever we're talking about.
That's right.
I think it might be worth noting that the person who does have the property, though, Victoria Lord, they could not be sort of summarily dispossessed, right? The other person who has an interest couldn't come by and just say, get off. There'd have to be some judicial process, an eviction, or some sort of proceeding, a partition followed by an eviction, something that would have to precede the person leaving the property, right?
Right, that's right. Because every person still has the full right to occupy the land.
Yes. And Michelle had actually raised her hand. Michelle, I believe I may have unmuted you.
Yes,
So
yes.
Okay.
I was going to answer that question. I'm actually an attorney, and you guys did a great job. My practice is in Texas, but my family is in North Carolina, and I grew up not too far from Winston-Salem, not too far from Wake Forest. So I definitely have an interest in knowing and about how North Carolina looks at it. But I was just going to say that the person has homestead rights if they're living in the property. So you guys got me before you could unmute me. So, but I was just going to say for the Partition Act, I know for example, because a lot of times when people have heirship property, it's very fragmented, and it's not, you don't really have, like I said, it could be 1/5, it could be 200 people. And it's hard to locate all of the heirs. And so it becomes an issue of notification and making sure that the parties are aware if the parties want to stay, if someone wants to stay in the house or keep the property, or someone wants to sell. It's about notifying all the parties about what's happening with the property. And I think when they said the grandson wanted, or someone wanted to stay in the home and then someone wants to pay, like, I want my money now. The sad part is that if the parties don't have funds to pay that party, it can be another issue of forcing the property to be sold, especially if they don't have the compensation to pay the heirs for their interest. So just wanted to add that.
Great. Thank you, Michelle. So I don't see any other questions there in the chat. But, just listening to Victoria and Laura, it seems that one of the ways to avoid finding yourself in this situation is that our loved ones have a will in place. Is that also a service that you all offer through the law clinic?
Unfortunately, at this point, we are not offering wills, but that may be something that is added as another service that we can provide from Wake Forest in the near future.
Okay. Great.
But you are right. A will would resolve a lot of these issues going forward, and certainly worth the time and effort to get one if you're able to.
And it looks like we may have one more hand raised. This is Rhonda Smith. Rhonda, I'm going to go in here and unmute you. Okay. That didn't seem to work. Rhonda, see if you, there you go.
I'm back. Rod, my
Yeah.
question is, you hear online wills all the time. Are they legitimate wills, or do you have to go to an attorney? I know we went through attorney, so do you have to go to an attorney to actually get a will? Because I've heard it so many times.
Okay, so Steve, this is in your wheelhouse, even though the law clinic doesn't do it. But when you see those commercials, where it's like, help, we'll develop a will for you. And just in terms of being completely transparent, when I was in college, a part-time job I had was somewhere out on 40 over in Greensboro. And my job was to call people who lived in Georgia and tell them what would happen if they died without a will. And I'll be honest with you, when I first read about it, I heard it and I'm thinking, well, why would you need wheels? And I was thinking round wheels. That was being called. But Steve, how would you answer that question that Rhonda's raised?
Yeah, I think, well, an individual can prepare a will for themselves, right? They can prepare a document that will have the same significance as a will prepared by a lawyer. I think, however, that, lawyers, they have a better sense of some of the complexity that's involved in passing an estate. And so I would suggest, if you can access a lawyer to help you prepare a will, that's a good thing to do. And I think that would be the better approach. But an individual certainly could prepare something for their own estate. They could not prepare something for somebody else's estate, but for their own estate, they could. And there was a question if there are any resources in Winston. Sadly, there are not a lot of resources for wills for folks who are unable to hire an attorney to prepare them. I do think that it is an unmet need in our community. Legal aid, I think, sometimes will do some elder law work. I'm not sure what their capacity is at any given time. There are document preparation services like, I don't know, legal, whatever it is that you hear about on
LegalZoom.
Yeah, I'm not a huge fan of those, but they are set up in a way that will help folks create a simple will, if that's helpful. But I believe they are even a couple $100 for that service. I could be wrong on the price, but I believe it's a couple $100. And I think that there are many lawyers that would probably do that same work for around that amount of money, or maybe just slightly more. I know it's still a lot of money, but I personally think it's money well spent if you have the ability to do it.
Great. We'll check chat to see if there's anything else. I think that may have been it.
Well, I want to thank everyone who dropped into the Zoom and folks on Facebook. If there are things that are helpful here, please let us know that. If there are things that we could have done better, please let us know that by email or call, whatever works. And Victoria and Laura, that was really very good. I just want to thank you for doing such a good job in helping us get this information out.
Exactly. Thank you, Steve, and thank you, Laura and Victoria. That was great information. And this session has been recorded. It will be on our Facebook page, and so you can go there later to access it. And again, thank you, Steve, for this partnership, and thank you to everyone who joined us this evening. And if there's nothing more, I wish you all a great evening and take care of yourselves. Bye-bye.